You say it.
All right. Hey guys, welcome back to the Paperstac Podcast. We are super excited today. We have our second guest on here, and this is somebody that I'm really excited to have on the podcast because A, I get to ask free questions that are not on the billing clock, but B, I know what a resource this is going to be for our users, and this is great. So we want to welcome Erin Quinn of Quinn Legal.
How's it going?
Hey guys.
Good,
how are you?
Good. We actually did have a request. Someone asked in another video, hey, can it'd be great to hear an opinion from a lawyer. So I was like, I know just the one. So that was when we reached out and said hello.
I don't hear, totally reach out to an attorney. They're awesome. I don't hear that much, so that's good.
No, we're good. I'm a lawyer's kid, so I have a special place in my heart for an attorney. I actually did a semester of law school, and I met my wife while I was in law school, and that quickly took a turn for I'm not doing law school. I think I'll go do real estate. So.
Oh, I didn't know that.
Yeah, I did. I went to.
That was me with the bar exam. I graduated law school and then met Bobby, and I did not do well in the bar exam the first time because I was too enamored with my wonderful husband. So.
There you go.
But I made it through.
Yeah, it is. You know what? It's funny. The first classes I took where I did criminal defense, but also methods of exchange. So reading the UCC, which is not fun. It's very dry. It's a book like that thick, and you can see through all those pages. So they're like the pages are that super thin stuff.
Oh, geez.
To where it's like it's so dry.
Yeah, that doesn't sound fun.
Nova, Southeastern.
Okay.
So I had their summer program.
Like you went there and met your wife, and that was your purpose of going to law school, and then now you're doing what
guess. Yeah.
Yeah.
I'm super fortunate though. Yes, exactly. So.
What was she doing there?
No, it was they do like a summer online program. You take I think it's 3 classes.
Was she in college there?
It's an online.
Oh, well, that's how did you meet her?
Yeah, so no, she was, I won't say where she was working. I was working in the restaurant industry, and she was too. She was working in a restaurant, so we met that way. But yes, that's
gotcha.
how I met her, and I was in school, and so I really liked, criminal defense. I think it was called criminal defense. It was criminal something. That was actually really interesting. Method of exchange was horrible. But we're not here to talk about me. Erin, we're here to talk about you. We're so excited to have you here. Tell a little bit about you. Tell us the story. I know you just have Quinn Legal now, and I know there was a little bit of you've been through a few firms, like owning your own firm. This is not the first time. This is you kind of bought somebody else. So tell us just a little bit about you so the users or the listeners know who you are.
Absolutely. I could talk about myself all day, so you guys are good.
Yes.
So I actually knew I wanted to go to law school when I was 3 years old, and or be a lawyer, I should say. And I threatened to sue a kid on the bus when I was 5, and I decided sometime in high school that I was like, why do I know what I want to do with my life, and none of my friends do? As the valedictorian in my class wasn't sure what she wanted to do when she went to undergrad. And so then I was like, well, maybe I'm pigeonholing myself and I should really look into being a doctor. And then I got to organic chemistry and I was like, not meant to be a doctor.
Mm-mm.
Criminology, criminal law, super exciting for me. I still watch the first 48 religiously, unfortunately for my husband. And I just stuck with the law route and realized that it really was what I was meant to do with my life. So when I was 22, I graduated from college and took a couple of years off, knew I wanted to go to law school. So I was actually also serving in the restaurant industry, making really good money.
Yeah.
And then ran into a couple 18-year-old kids that were working in a firm, and I overheard them at the table. So I started talking to them about wanting to go to law school and stuff. They're like, oh, you should apply to our firm. It's so great. So then I just annoyed that firm until they actually hired me. For probably, I'd say 4 or 5 months.
Oh, wow.
And ended up in the default world because of that, actually. So I don't know, I initially didn't ever think I'd want to litigate. And I actually like it a lot better than sitting in my eyes bleeding over contracts, to be quite honest. But I ended up at that firm as the receptionist and kind of just worked my way through it. And then once it was time to go to law school, left to go to law school, worked there on my breaks. And then from there, everything has been very relationship driven. So that first firm was a Chevrolet and Associates, which eventually became Ron Wolf and Associates. And Andy Fivecoat was my boss there. And when he left, he went to Albertelli Law, which is another big local firm in Florida here, and several places around the country now. And they were getting out of the retail market and into the default market because the recession was about to hit, and their closings kind of went away, and they were, trying to pivot and have something cyclical to the retail market. And so when I found that out, I offered to work for free just to get my foot in the door, and started at A-Law when they were 4 people before me. I was the 5th. And then we let go of 2 of those people. So I was one of 3 OGs, and then we grew the company to 400 people.
Oh my goodness.
So that took about 7.5 years to do. And I learned a ton about opening a business and the technology aspects of how I can use technology to really drive the pricing. This sounds really bad, but drive the pricing down for the investors. Bad for me, I guess. Good for you guys. Drive the pricing down and offer Fannie Mae rates across the board to any investor, because the files are generally the same. They are a little more work on the smaller investor side, but overall, using that technology to offer better pricing to the smaller investors was kind of my goal. I don't think I ever intended to own my own firm. I was perfectly happy being a W-2 wage earner and not worrying about everybody else's families and going to work. And I worked my butt off. I mean, I worked, 12, 14-hour days sometimes, 45 days in a row without a day off. And, really was trying to get on the partnership track at that point. But, some things happened, and it made me realize that wasn't what I was meant to do. And somebody reached out to me and headhunted me, asking for my resume because they wanted to hire me to start their firm. So I went through a process with them and ended up opening that firm, which was eventually, when we were about 15 people, which I would have stayed there forever. We were about 15 people when McCullough Raymer acquired them.
Oh, wow.
So when they were acquired, I had a client that did not want to go to another big firm, and they were a decent sized client for me, and they wanted to stay with me. I never asked for the business. They just offered it. So I was like, okay, well, how do I do this? And so I ended up deciding to try to go out on my own. Went to a friend's firm for a little bit. We tried to mesh our business lines, and it just wasn't really happening.
Okay.
They're very hourly billing driven, where, default is very percentage, milestone, weird time frames, net 60, net 90 payments. They're used to net 30. And we weren't able to really assimilate the firm very well. So I think it was probably about 6 months when I just went to him and said, hey, I feel like you feel the same way as me, so let's talk about it. And we ended up agreeing that it was, a time to part ways. So at that point, I reached out to my mentor of 18 years, Robert Bowen, to start the firm, or to basically ask his advice on my next step, honestly. And he was like, why aren't we starting a firm together? And I was like, I don't know. It's Wednesday. How long have you been thinking about this? He's like, about 5 minutes. I was like, you let me know on Monday if you're still feeling the same way. And he was. So we, ventured off into this partnership together. And eventually in August, I went ahead and bought him out. He's, just kind of taking his time in his personal life and taking some well-deserved time off after being a partner of a large firm for a long time.
Yeah.
So, I bought the firm out and just kind of decided to rebrand after a few months, and here we are.
That's awesome.
So I've been doing it about 18 years.
That's
Wow.
18 years in the industry. A lot of, Albertelli Law, I remember them. Had them on my cases several times, so I know very familiar with Albertelli Law. I didn't know you had been through there or helped start that firm.
Yes, yeah. And they, I was a legal assistant at the time I helped start it. I think I was probably the 13th attorney or something like that, because I did get my bar license while I was there. But, I can't say anything bad about that experience, just because it brought me to where I am today, and the strengths that I have on the technology side and the business operations side are because of them. And so, them giving me those opportunities, I appreciated that immensely, and, hopefully he continues to do well. So.
Awesome. So you're licensed in both Florida and Georgia, is that right?
Correct.
Anywhere else you're looking at doing, or are you going to kind of stay there for now?
I am actually licensed in DC, but I never tell anybody that because I don't, it's not, Florida and Georgia they're both here. I have to eat the elephant one bite at a time here. So we've got Florida and Georgia working house. I've also got bankruptcies and evictions. I'm licensed federally in both states too, in all of their jurisdictions. So I'm kind of focusing on getting those up and running. I don't know if I'll end up ever working in DC, but I have had a couple people ask me about North Carolina and South Carolina and Texas. So, eventually I might pick up one of those. I probably would want to keep it non-judicial, especially if I have to take another bar exam, because I'm so over them.
Yes.
But, one step at a time. I want to get a couple more. My 2 associates that I have now, I want to get them licensed federally and in Georgia, at least one each for now, so that I'm not covering down all that work, in addition to my management duties that I've got plenty of here. So
yeah, cool. So you're in the default space. It seems like you work. You're like a boutique shop that you're real customer service driven. I know from experience, I never have an issue of getting you on the phone. I know you are busy, but you always make time, whether crazy hours too. I sometimes we're Facebook friends, so I'll like something around 10:30 and I get a text, so you're up, you want to talk about this, which is cool. I don't know that you gave everybody that, but I feel special with that. I want to talk a little bit about some of the stuff that you see are sort of mistakes that maybe happen because you do deal with the smaller investors, or maybe not necessarily, not with big hedge funds, but people that have, 20, 100 loans, something like that. What are some of the biggest mistakes you see when you start looking over your clients' files and say, ooh, maybe you should have caught this in due diligence? Here are some things, just some tidbits, little nuggets that we can throw out there. They're like maybe the top 3 or 5 things you see, like, oh, make sure you're looking for this.
So I know this is going to be an unpopular opinion. However, one thing I can definitely say is if you can get an attorney involved in the process, I 100% recommend it. The reason being is that, and really specifically for the state that you're looking at the documents in. And the reason I say that is this. I've come across, I don't know how many times, in Georgia specifically, for instance, the laws on assignments of mortgage changed in Georgia in 2015. And instead of allowing a witness or 2 witnesses and an acknowledgement on the notary, they're now requiring, since 2015, 1 witness and a notary jurat. So the notary jurat has to say that the document was subscribed or sworn to in front of the notary public, not acknowledged. So it actually has to be signed in front of the notary public. And there are so many instances where I get title reports back in on these loans, whether it be at the institutional level or the smaller investor level, and they've got a chain of assignments, but the assignments aren't executed correctly. So you're going back and having to do all of these corrective assignments. There's probably not, absent keeping your own matrix, there's probably not a huge way for you to incorporate that into your process. But that notary jurat is definitely a big thing. And that's something that I deal with often. So, and the funny thing is what's so weird about it to me is that, with Georgia being an attorney closing state, the amount of title claims I see come out of Georgia is insane compared to Florida, with we're cowboys and everything down here.
Definitely cowboys.
I think that is probably one of the biggest ones, is just the little nuances from due diligence, the assignment chains specifically. And, most of the allonge chains, they can usually get them right or get it fixed, because there's not a lot of execution requirements on allonges, because there's not, a sworn statement involved and a notary public involved and stuff like that. The UCC allows a lot more loosey-goosey of a process there. So another thing I see a lot is people indicating that they have original collateral when they actually only have copies.
Yes.
Making even like missing, so the nationwide title products that are out there, I'm sure are helpful, but they're not, with them not being state specific, you're gonna have things that are missed. And I've had things like a loan that essentially becomes superior through certain statutes that looks inferior on a title report without identifying it, for instance. In Florida, that case was the city of Green Acres, funny enough. I don't know if you guys ever heard of like Black Acre and White Acre from law school, but that's a big PTSD moment for most of us that have been in property law. And the state of Florida basically made this rule where you could, under this, I think it's called PACE, under the certain program in Florida, you can put energy efficient windows, hurricane rated glass into your house. I think solar panels might be included in it too. And you can do it at no cost up front, but what happens is you pay them back through your taxes with the county. So as you're working through your permits and stuff like that, like it kind of goes into there and it gets basically taxed on or locked onto the back end of your ad valorem taxes for the property, and essentially becomes a superior lien to the mortgage. So you're renovating the home, and understood that the bank, does benefit from that to an extent, but that's not something you signed up for when you recorded your document. So, we have some of those things that I see happen. Or
can they do that? Can they just jump? Can they jump a bank in line?
They do.
Wow.
There is no case. Okay, so I have researched this issue to death because it's happened on 2 of my cases. And there is no case law on it. It was brought through the legislature. It was amended into the statutes. Like everything was done, at least from what I can tell, was done properly for them to allow that. And there were hearings that allowed people to object. Nobody showed up to object. So it's one of those things, a lot of times with the legislature, what we do is we really ignore what's going on in the law and what's going on at the policy making level until it starts to affect us. So once it affects us, then all of a sudden we're like, this is crap and needs to change. But until somebody does that, it's going to stay that way. And that's, I think, what happened here. It got slipped in at some point in time, and none of the big banks realized it was going on. Nobody lobbied against it to stop it from happening, or if they did, it wasn't sufficient. And so it ended up in our laws. So I actually named the company as a defendant in one of my cases just to see what would happen. And of course, they sent me a motion for sanctions, like, you need to remove us, we're superior. And so we kind of went through this lengthy discussion about the superiority of these liens as opposed to, for instance, the superiority of HOAs. And several years ago in Florida, there was a big body of case law that came out surrounding the unconstitutional impairment of contract with respect to HOA dues, because the HOAs were starting, now that they weren't getting money out of the borrowers and were really looking to hedge their losses, were taxing, like changed the statute or had the statute amended, had their declarations amended to require all these payments back from the bank when the bank foreclosed and whatnot. So we went through essentially a period where there was a lot of fighting about whether or not the HOA was superior to a first mortgage, which has now been settled that it is an unconstitutional impairment of contract. So you can't.
It says super lien or something like that.
Yeah, similar, yes. So basically, they said the HOA can't become a super lien on contracts that already existed. So anything new now, they are subject to the statutes, which does limit their liability to 12 months, depending on the condo HOA situation. But there's very specific requirements for it now. So most of them basically end up smack in the middle of a first and a second.
So is it a safe harbor? I know we foreclosed a lot, and I know in Florida it was either, I think it was 12 months of payments or 1% of the loan balance. Does that sound about right? Mm-hmm. Yeah. And so
that's right.
But man, even then, some of the HOAs would be like, no, we're not if you're, usually it would pop up when you're at closing, waiting to close on something, you're waiting for your estoppel. And so it's like, well, it's going to delay closing by a month because they say, well, we have, I think it was 14 days to respond. And it's like, well, I need to close next week. They're like, well, we have 14 days. You could pay our fee to make it go faster. And they nickel and dime you and hold your feet to the fire. And it's awful. And I hate them. I hate HOAs.
Yeah. And they eventually litigated that issue and it's pretty settled now. But it definitely for a long time, they did absolutely try to hold the banks and other people hostage on that situation. And it was either like close it or let your closing be delayed and fight me. And then you're spending money fighting them, money that you potentially can't recover. And a lot of people would just go ahead and pay it just to get it over with. But it's definitely now pretty settled that it's going to be like smack in the middle of that first and second. And the 12 months is relatively accepted now as the accurate measure of that. That said, the statute technically reads that it's up to 12 months of back assessments from the year preceding the certificate of title, but it's unpaid assessment. So if the borrower paid 6 months of that year, specifically, even if they didn't pay 4 years beforehand, if they paid 6 months within that year, technically they're only entitled to the 6 months.
Wow.
But I think most people just view it as a 12-month across the board, which is fine. It's what they're willing to pay to get their closing done versus arguing with them. So
that's interesting. I had a question about, so have you done any litigation using electronically notarized assignments? Have you dealt with that yet? Have you heard any case law on that yet?
So nothing necessarily yet. I know that Florida started allowing online notarization, a while ago, but I think most states have, electronic signature allowances in them. I'm sure there's some that don't. Florida specifically, if it's electronically signed, as long as the person actually caused the signature, then it's fine.
Yeah.
They are still funky about some electronic signatures. For instance, like on a complaint, I always have to have a wedding signature because they'll kick it back.
Yeah.
So, but for the most part, especially as like e-recording and e-filing has become more of the norm, I'm seeing less of the issues with the electronic signatures. What I haven't really had to deal with yet is like e-notes or like the DocuSign, notes that have a trail of who signed what and when.
Yeah.
Haven't really gotten into that too much yet.
What about the allonge? I know definitely most of the time people want wet ink notes. How about the allonge? Do you feel comfortable with a digital signature if you're going to litigate that? You're like, look, I'm okay with a digital signature. If it's their signature, it's matching, good to go.
Yeah, I would say, the best practices would be for it to be a wet ink signature just because you avoid the argument completely and we're in the business of mitigating risk. But I still think that there's an argument to be made specifically in Florida that an electric signature on a allonge is fine. Endorsement stamps, if you have a stamp with your signature, you can stamp it. What's the difference? As long as you are doing the action that's causing that endorsement and you're not, my stamp was stolen or my, electronic ID was stolen online, then I think that you should be good. And the good thing about Florida law too is that any signature on a document or any attempt to sign a document is considered authentic unless the defendant any original signatures anyway, I should say, are deemed authentic and can't be, what's the word I'm looking for? Like can't be controverted unless there's specific evidence to show a fraud. So a lot of times they try to put it on us like, the signature isn't, an actual signature. The courts have found that, it's basically presumed authentic. If it's a copy, it's not going to be presumed authentic necessarily. Right. But in an original situation or, anything where there's a stamp endorsement or whatever, they're not really giving too much credence to that argument, at least not yet.
Doesn't that make like what we use notarized probably even that much better because it has
video?
Video.
Yeah, like our notarized sessions.
It's kind of hard to fake that.
It's much like this. I'm in a video chat with somebody. I have to show them my ID. I have to answer 5 questions that prove that I am who I say I am, and then they video me actually doing the execution. So I'm like, man, that's better than
a stamp.
Yeah.
And it's
I think, technology is definitely catching up finally to the industry. And I do see, we're going to see a wave of those types of situations as time goes on, because you're going to have a lot more electronic signatures as technology increases. And as, I think that COVID really pushed us into that a lot.
Threw it in the microwave, right? I feel like COVID threw the whole digital technology, everything into a microwave and just hit it on, let's nuke this thing. It's got to come out quicker now just to keep up with.
It's glorious. I love it, because let me tell you how many times I've driven to South Florida for a hearing that did not need to have me there, like in person staring at a judge, when I could seriously be doing this right now. So it is actually, I think that COVID kind of, aside from the technology piece, it forced courts to think outside the box and finally go online, for a lot of their stuff that could really be done without having to have somebody there in person. It forced them out of those traditional roles of, their attorneys having to be sitting in front of them in a suit and tie and shoes and the whole nine. I remember even when it first started, like the judges at first were like making people stand up at their desks and turn around to show that they were wearing court appropriate attire. And now they're like, I don't care.
Yeah.
So I think that things are definitely moving in the right direction with it. The other thing here too, though, that we have to remember is that as technology grows and it is introduced into our court systems and into our lives as investors and, people that carry collateral, is the fraud aspect is also going to go up. So, it's going to be interesting to see how the industry handles poking any holes in some of these, electronic signed document situations, Adobe Acrobat, for instance, or Notarize, or whatever the name of that company is, or e-notaries, or depositions that are done, via video. But I think that we're definitely going that direction for most of it, and I'm happy about that. I think that it is a long time coming, and it's going to make, it'll even affect the bills for the clients, because ultimately, if I'm traveling to a hearing, back and forth to a hearing, and I'm charging you, 6 hours to attend a trial that money. Took me, 30 minutes, then it's going to be better on the bottom line budget for everybody.
Yeah, so. I agree.
Wait, so just out of curiosity, what is a court attire? What do you have to wear?
Suits. For men, it's suits, ties, nice shoes. Women, we can get away with a lot more because our outfits are cute. But, a lot of suits, pantsuits, skirt suits, dresses, anything that's like business casual attire, to an extent anyway, can be done in court.
What about now?
So there's definitely a dress code. So if you show up without a tie, are they like, where's your tie?
Yeah.
Still?
Depends on the judge too. So some of the younger judges are going to be a little more lackadaisical about it. The ones that are, older are going to be a little more traditional. That said, some of them might not say anything, but you don't ever want to get in front of a judge where they do say something. So it's always a, better safe than sorry situation.
Yeah.
But again, I wore some questionable things when I was pregnant and just wasn't feeling like getting in a suit, and wore some cute dresses that probably I wouldn't have been caught dead in court before I was pregnant. But, it's just going to depend. If you look presentable, witnesses and stuff and, clients can get away with a little bit more. Maybe not necessarily the bank clients just because they're in court so much.
Yeah.
But the ones that are just there for their family law case, or, they'll let them wear jeans or, stuff like that. But for an attorney,
Cool. Wow. What is, yeah.
That.
For sure. What do you think what's your opinion on self-servicing as an attorney versus hiring a professional servicer?
You hit a chord a little bit on this one. So I'm not a big fan of self-servicing, not gonna lie. Here's why. Number one, there's a lot of compliance. Servicers handle all your compliance for you. CFPB rules, Dodd-Frank rules, all that stuff. Perfect. They deal with it all. They send your notices. They make sure that their systems are updated timely. There's not all the nuances in the foilables. That's a crazy lawyer role or a lawyer word, but all the foilables associated with I'll do it later. I've got 20 notes and I've got to put all these payments in, but I don't have time right now, so I'm just going to write them all down and put them in later, things like that. So the records become very spotty / potentially inaccurate, and I hate that. So I do deal with that a lot now with the smaller investors, because they think that I can totally just accept payments every month. It's fine. Yeah, it's all fine and dandy until you want to sue them, and then all of a sudden you don't have a payment history.
Right.
So the amount of loans that I don't have a payment history on for the past year or 6 months or whatever is insane with some of these smaller investors, and that's absolutely a death sentence in Florida. So I prefer, and especially
say that one more time.
My understanding.
That is absolutely a death sentence in Florida.
It is a death sentence for your case in Florida to not have an accurate pay history.
Okay, go on.
So I say that there are obviously caveats to that. I file cases without that pay history, letting the client know what the deal is, because it's a proof thing at trial. So what your goal is, if they start contesting, you settle it.
Right.
And that way you can start the pay history over from a mod, for instance. So it's really going to depend on the case-by-case situation. You don't have to have every payment history from the beginning of the time, although that is absolutely preferred, especially in a contested case. But there are ways to get in a newer pay history and rely on those specific records. Admissions of the borrower, getting a modification, and then starting your pay history from the modification date is another one.
So we've been purchasing a lot of a lot of owner finance stuff, marketing for it, performing it, and most of the time when I ask for payment history, I'm getting a little, a sheet of paper that has what's it called? The amortization schedule. The amortization schedule with little tick marks on there. And so what we've done is we've started drafting estoppels and having the borrower sign them and getting them notarized, saying, look, as of the day we're purchasing this is what you owe, here's your interest rate, here's, this is everything up to now. They sign it and have it notarized. Would you feel comfortable utilizing something like that? Look, that is good. That's the borrower saying that's what I owe.
I feel comfortable presenting that to the court. Absolutely. It's an admission of the debt. I would say in that specific scenario, having the owner finance pay history with the little tick marks is awesome, because even if it doesn't have the actual figures themselves, it does show that they made the payments. So another way that it could be done is you can just cut it off. When you purchase it, for instance, if there's missing pay history, you just make sure that wherever the payment history ends, that person was current.
Okay.
So if they were current at that point in time and they defaulted while there was a pay history, or they defaulted while you own the loan because you brought it current when you bought it, for instance, then I think you can do that as well.
Okay.
So there's definitely ways around it. It's just not an ideal situation, but I agree. I think that having the borrower sign that admission, if you, in the absence of nothing else, isn't a bad idea to do, because at least you've got something where they agreed with you that that's what they owed.
Okay.
And there, cases too where statute of limitations.
That's what I was going with my next question.
So we've gotten, the borrower to mod and extend it. So that way, even though statute of limitations ran, they just basically reaffirmed the debt by signing the mod. And that allows the creditor to then proceed with an action if they default on the mod. So on that issue, though, on the statute of limitations, not to change the subject, but it actually goes back to your first question, too, is one of the things that I've seen even experienced investors do is rely on the tapes for their modification or their maturity dates. They look at that, okay, boom, 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 there's no maturity date issues here, we're done. And then I get the paperwork in to start a foreclosure, and I'm like, where did this maturity date come from? And they're like, I don't know. I thought, it was in the records of the bank. Well, okay, that's great, but where's the document? Because the maturity date has to be, at least in my states, in Florida and Georgia, has to be of record. So it's got to be recorded in the public records. So I have a case right now where the loan matured and the statute of limitations ran well before our client purchased the note and mortgage. It got to our office and I was like, you have a mod because this doesn't match the date on I think it was Georgia, so it's a security deed. And they have no indication of the modification, like a written signed modification. And the prior servicing systems basically say something along the lines of, oh, we just gave them the most favorable terms, and that's all it says. So it's very important to make sure that whatever the maturity date is, you have a document that supports it. In Georgia, for instance, you would have to record it, or else, because Georgia's reversion statute essentially says, like, if you don't file suit within X period of time, the property reverts back to the grantor and it's just gone. Like there is no, like, unless they reaffirm the debt somehow, there is nothing there. And you have to record it before that time period runs. So in my scenario with my client, if I had the modification and I had been able to record it within 7 years of the maturity date on the security deed, he would have been fine. Because at that point, there's something of record saying, yes, they owed it. But it's been 10 years, nothing's recorded. I have no copy of a mod 2 record. It reverted, 3 years ago to the grantor. Like he's in a situation where he's got to try to get them to reaffirm that promise in order to really enforce that debt. So in that case, it's always good to have an attorney in it just because usually you can, as soon as they lawyer up, it's like, thank God, I can potentially modify this if the lawyer isn't really looking too much into the technicalities of getting out of the debt. So if you record the mortgage in Georgia, though,
deed of trust.
The deed of trust, deed of trust in Georgia, you do have the maturity date on that.
If it's on the document.
Security deed will have a maturity date on it, but if you extend it in order to keep it as a lien on the property, you have to record that as that
mod.
Oh, okay, I got you.
So yeah, so it's just basically showing that extension, and that's for the public records. It's really not to get too much in the weeds, but it's really more about third-party notice and people being on notice that lien exists. So what can happen right now, for instance, on the file I'm working on, is she could refinance the property and a security deed could be recorded, and our lien is now gone because they're a bona fide lender, basically. And we didn't record the modification time, or my client didn't record the modification timely, or his predecessor.
So they could lose it, huh?
So.
That's
but
scary.
Yeah, so servicers,
that is scary. Wow.
Servicers, $30 a month, do it.
Well,
I think that's what their price is.
It's lower than that.
Yeah, if it's performing, you can get them for like $15. If it's non-performing, it goes up a little bit. But for me, I say it's cost of doing business. If it's going to non-performing, you have to look at it and say, that's when you're gonna really find their worth, because that's when you're going to court. The other side, if it's opposed or contested, then they're gonna be firing in all kinds of stuff. They're gonna be asking for
I'm just, the fact that they just even keep up with the compliance laws and stuff like that. If you think about it, when you initially start servicing the loan, you've got to have a hello letter. And it has to be within a certain time period.
Yeah.
If you are reaching out to them about the debt, they have to have an FDCPA, letter at some point in time. If they request verification of the debt, you have to be able to deal with that. And these servicers are built to deal with all that kind of stuff. If you sell the loan, they can, generate the docs for you.
Yep.
Or if they sell on Paperstac, you can generate the docs for them, by the way.
But
So I think that, those aspects alone, but then think about it. Every year anybody that has an escrow account, they have to have an escrow analysis done. You've got to worry about compliance with the escrow rules. So there's all these state and federal guidelines that the servicer will basically handle and deal with for $15 a month. We're talking like, what? Yeah. I don't do math very well. I'm an attorney, not a mathematician. Like $250 for, a year. Like, seriously, not even a payment on some of these things. So, especially with the FERC.
Yeah, so. It's well worth it. So I threw that out there as one because I knew, I was like, I tell people all the time, like, don't even bother. Don't even bother doing it. Just pay the money. It's so worth it. So I wanted to make sure. I wanted to see your reaction.
$300 a month. Okay, I get it. But $15, man.
Yeah.
Don't they also have? They have the insurance too, right? They have the forced
place insurance.
Yeah,
they usually have policies lined up to where you can go under their umbrella. Yeah.
So I mean, even if you didn't, and still wanted to get the insurance, it's going to cost you more. You're like, so that's a no-brainer.
And even the phone calls they have to take. Processing payments every month, logging those payments, figuring out all the calculations, making sure the interest rates are adjusted when they're supposed to on things that are needing adjustment, handling mod docs if you have to mod, they can do so much. And, not every servicer is equal. Obviously there's some that have better documents than others. And I always recommend using an attorney so you know what you're getting yourself into in that situation. But yeah, absolutely, it's worth it, 100%.
Cool. So we're actually running a little out of time. I want a couple more things. So services that you offer obviously foreclosure, initiating foreclosure, litigation. Do you offer pre-purchase collateral review? Is that a service that is at your firm? What else should everybody listening know about your services? And then I'd definitely like to get your contact information so they know how to get in touch with you and we can start getting business your way.
So the firm itself, aside from just the run-of-the-mill foreclosure, contested, uncontested stuff, and bankruptcy, I do due diligence reviews pre-purchase. If somebody wants me to do that, then I will do it. For the first ones, just because I like people to be comfortable with the amount of information I provide, because I do provide a lot. I do only charge them $100 for the first batch that they send. So if you send me 10 loans tomorrow to do due diligence for the first time, it's going to cost you $100 a piece, just so you feel comfortable with the investment and you can see the product before I then start charging you $300 because it's way more work than $100.
Okay.
So I do try to, at least do that so that, and I want people to trust, the product before they, start having to spend money on it.
Just like any good drug dealer, give them at a discount up front and
right.
Yeah.
True.
So
I'm sure that's how all the dispensaries do it nowadays. $75 off your $150 order. Come in on your first one. So the what else do we do? So we do a lot of contract review and transactional stuff on that side of things. I think eventually I'll work towards a full service title company as the need arises. And totally not in this industry, but wills, trusts, and estates and probate. I do those as well. My associates actually have some pretty extensive experience in some high net wills, trusts, and estates things, and also high net individuals for probate with my second associate that I have. So we're all kicking around and starting to get into that a little bit to see if we're going to develop it as a product line. So we'll have some decent pricing on that to start off with, just so that we get our feet wet with it. I can, sit down and draft everything and implement all my technology and all that kind of stuff. I'm trying to think what else.
I know you're definitely doing contract work for us as far as working through our statement of work, services agreement, looking at our purchase sale agreement on the Paperstac side, signing stuff up. You've got definitely a foreclosure work from us. So yeah, I think it's kind of. You're not doing criminal defense, right?
No.
Okay.
I don't deal with people problems. I'm not a people problem person.
Business
problems are okay. I don't like emotion involved in my business decisions, and so I just can't fight over chandeliers and dog custody.
Perfect. So we'll keep it to business problems, Quinn Legal. What's the best way to get in contact with you? To have listeners who need legal work in Florida or Georgia?
So I do spend a bunch of time on Facebook, number one, so you can always message me on Facebook. But I'm on Clubhouse too. I don't even know what my names are on those things though, but I'm pretty sure you can find me pretty easily. I'm probably the only Erin Quinn in Clearwater, or Oldsmar. Then my office number is 727-474-9603. My cell is 813-992-5778, and my email is equinn@legal.com.
She put the cell number
I know,
out there.
I know. You know what though? To be quite honest, like I'm able to screen calls. If I can't answer, I can't answer. If I can, then I will. And
Sure.
so, I don't have too many people that abuse that privilege of my cell phone. They leave it at night for emergencies for the most part, unless I reach out to them, obviously. And, it hasn't been too bad for me. And it's even on my card and on my email. So probably the best thing to do is just send me an email at equin@quinnlegal.com. And then when I reply, all my information's there.
We will put links to that stuff in the show notes. We appreciate it. Good to talk with you.
Went really fast.
It did, I know.
What's that?
It was pretty
I have way
quick.
more to talk about, man.
We have way more to talk about, and probably what's going to happen is we're going to have, usually these things start kicking out questions from listeners, so next time we'll probably have another slew of questions and get some specifics and stuff like that, but thank you so much for coming on.
Help anytime. I mean, nothing I give you guys, like the more that I can provide you guys and the more tools I can give you to help you in your business, the more it helps me in the long run. So, you got a ton of free legal advice the past hour, and I have more anytime.
Awesome. Cool. Well, guys, listen, that was it. Erin, Quinn Legal. Come back. Check us out again. We'll be back next week. Hope you enjoyed this one.
See ya.
Cool.
Bye, guys.
Cool. See you later.